Is now back in session. The Honorable Judge Cedric Simpson presiding.
You may be seated.
That's who I was talking about.
Where's your phone? Yeah, right. In there one. It's 12:30.
It's a Tuesday, so gotta wait.
We had to wait.
Yeah.
All right. Court does call the case of the People versus Benson.
Ready, Judge?
Good afternoon, Your Honor. Katie Rismer, for the People.
Portia Feaster, First Assistant Public Defender, on behalf of Ms. Benson, who is approaching the podium. Ms. Benson, when you arrive, please state your name for the record.
My name is Shalon True Benson.
All right.
Thank
Your
you, Judge.
motion, sir.
Yes, this is our motion, Your Honor. We filed a motion to withdraw on this case. I have had the opportunity to speak to Ms. Benson on this matter several times and to discuss the nature of this case. At this time, it has come to the point where there is an attorney-client breakdown of communication. I do not feel that I am able to effectively communicate with Ms. Vincent to help her with this case. This being a capital case and her fighting for her life in this matter, I believe she'd be better served with another attorney who she feels more comfortable with. And based on that, Your Honor, I ask that you allow our office to withdraw.
All right. Do the people have a position on the withdrawal? Ms. Vincent, is this what you desire also?
Yes, I do. I need my own private attorney for this matter pertaining what's going on about my child. And I definitely stand tall for my baby. So I need for him to withdraw, I need to have my own attorney.
Well, when you say your own attorney,
Well, a different attorney.
you need a different attorney than the public defender's office.
Correct.
You would agree that communication between you and the public defender's office is broken down?
Yes.
All right. Given that, the court would indicate that the public defender is permitted to withdraw as counsel of record, I will sign the order. Discharge from any further obligation under the
I
case.
got it for you.
Sure now.
Stand tall for my daughter. Sorry.
The court, in anticipation that this might be the court's ruling, although not having decided it previously, the managed assigned counsel's office has appointed Corinne Johnson to represent Ms. Vincent.
Thank you very much, Judge. I believe he's here. Good luck to you.
Good afternoon, Mayor. Please, this honorable court, Kareem Johnson, on behalf of Ms. Vincent.
And so, and the record should reflect there was a in-chambers conference, basically trying to anticipate, go this direction, where the public defender was to withdraw, anticipation to make sure that you'd be ready to proceed to preliminary examination. Without getting into the details of that, I think that all the evidence and other things will get to you rather promptly. And so I'd like to set this to adjourn the preliminary examination to August 5th, that Tuesday in the afternoon. And Ms. Vincent, you understand that having allowed the public defender to withdraw, that your matters would be adjourned.
Yes, I do.
All right. Will that work for counsel?
Yes, Your Honor, the afternoon of August 5th, believe will work for counsel.
All right. Will that work
People will
for?
be ready, Your Honor. Thank you.
All right. Then I will adjourn preliminary examination in this matter to August 5th, 2025. What I'm going to do is I'm going to set it at noon. As counsel is aware, there are preliminary examinations that are going on during that time. And so because I would need a courtroom with a lockup, I have to wait for those to clear, and then we would proceed immediately thereafter. So I'll set it at 12, but it may be a little bit after that.
Yes, sir, Your Honor.
All right. Anything additional?
Yeah, I just, oh,
Nothing further, yeah.
Thank you. All right, bond will continue as denied. Thank you.
Thank you.
And I get all of that. Okay, before they break down, is Mr., give me Mr. Burgess. Have them bring Lee. Try to get that one. Did you get his? Please.
He doesn't have.
Got it. And my copy is, do you have my copy? Okay. Is it in there?
Within the file. When I went to put this back, I don't know what that that's on this file.
So this is different than what was sent to you?
Well, I don't. So this is what I'm.
That was JIS indicate that they have some. They're gonna have to wait. They're gonna have to wait. Because the rules require you gotta wait for me to tell you you can break down. I gotta call another case. Then I'll give you an opportunity to break down and get yourselves moving.
The 14A District Court opens as Judge Simpson takes the bench, gavel poised, eyes sharp. A packed docket awaits, tensions hum, and seconds count as lives, leases, and promises collide.
7:18. I assume, and I don't think that that's time stamped,
Which is,
the one that you just had. Yeah.
that's the one.
So I believe that's the one that comes with attachments.
Hey, can you communicate with them, see if we can get Burgess over here? I don't know if he's in there.
AK Kennedy just checked, he wasn't next door, so AK Kennedy is not calling Mr. Burgess.
So. Who else do I have back there that they can? Is that a withdrawal? Waivers on Merriquin. Okay, let's switch it up and get Merriquin out here because I don't know where he. Huh? Okay. Court does call the case of the people versus David Merriquin.
Good afternoon, Your Honor. Petitioner Yuri requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Archie Lumpy.
Permission to practice is granted.
And good afternoon, Your Honor. Alex Warren Green on behalf of Mr. Merriquin. Your Honor, currently in both matters,
And covered open hearing on matter 25F5-.
Well, I don't think I've signed the order, Mr. Riddell, but
Correct, Your Honor. Mr. Merriquin, can you state your name for the court?
David Merriquin.
what is happening on this?
Your Honor, our office did discover a conflict, and I apologize for any inconvenience that causes. I apologize for the late notice, but we are requesting to withdraw. We believe we have a material conflict in.
That's in the case ending in 5622.
Your Honor, I'm getting that case number. It is the 5622 case, Your Honor.
Mr. Merriquin, you understand that?
Yes.
All right. You have any objection to withdrawal of the public defender?
No.
All right. So in that case, that being 5622, the public defender is permitted to withdraw. Signed counsel assigns Mr. Riddell to represent him in this case.
Covered on behalf of David Merriquin.
All right.
Your Honor, with respect to the matter ending 5132, at this time, Mr. Merriquin does wish to waive his right to a preliminary examination, and I believe Mr. Riddell is doing the same thing.
He does as well, Your Honor. I just need him to, David, I just need to have you execute this form. You can sign. I got a pen for you.
So he's waiving on both cases?
Yes.
Correct.
Mr. Merriquin, is that correct?
That's correct.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have a hearing on either one of these matters and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right?
Yes, Your Honor.
Preliminary examination have been waived. Defendant is bound over on a single count in each case.
Your Honor, we acknowledge receipt of the information, waive its reading, and stand mute.
Acknowledge receipt of information, waive its reading and stand mute.
Defendant having waived formal reading, standing mute in both cases. Court will enter a not guilty plea. Pretrial in these matters will be set for
August 7th at 1:30 with Judge Slay.
August 7, 2025, 1:30 before Judge Slay.
Thank you, Your Honor. May I very briefly address bond?
Very briefly.
Thank you, Your Honor. At this time, we are asking the court to consider either a personal bond or a release to treatment. In the event Mr. Merriquin were released, he would reside with his parents in Ann Arbor. They're both responsible members of the community. I understand he came into custody after cutting his tether. He did turn himself in after that. He acknowledges that he did that. He tells me he was going through what he describes as a mental health crisis at that time. So, Your Honor, we'd ask the court to consider either personal bond in, I think Mr. Riddell's joining my argument, or a release to treatment. He has expressed interest in mental health and substance abuse treatment.
Judge, I would ask to join that motion as well.
Response.
Your Honor, actually, because people at this time people would object to any change in bond. Your Honor, it's important to note that on the malicious destruction of personal property case, the defendant was actually on probation for a different malicious destruction of personal property case with the same victim when this event occurred. Furthermore, he was found with 2.2 grams of crack cocaine. That is the possession case. So I'm concerned with his ability to remain law abiding. I understand the court may want him released to treatment. I respect that decision, but with him being on probation for an event of picking up 2 new felonies, I'm disinclined to agree with defense's request.
Anything else you want to tell me?
Nothing further, Your Honor.
Motion for bond reduction, given all of the circumstances, and I addressed some of these issues before. The motion for bond reduction is denied. Bond will continue as is.
Thank you, Your Honor.
Thank you. Figured a great name. Let's try to get that. They're ready. Court does call the case of the people versus Larry Lee.
Good afternoon, Your Honor. Marie Townhouse, this was attorney, people.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess, currently representing Larry Lee.
Your name, sir? Larry Lee. All right. Mr. Burgess.
Your Honor, based on representations or communications I received from the court, Your Honor, I filed a motion to withdraw. I also received a letter today from Mr. Lee that the court made me a copy of, indicating he wants to represent himself. So based on the motion I submitted, as well as this letter, I'm asking the court to allow me to withdraw as his counsel.
And just so that the record's clear, the court received from Mr. Lee what were, in this court's opinion, I did not read them fully and only had a staff member relay them to me, were, I would say, privileged communication to the extent the privilege would still exist between Mr. Burgess and Mr. Lee. That is what I, based upon looking at them, what I presumed.
Zoom mishaps and no-shows derail cases. Cameras fail, mics mute, names mislabeled. The judge pauses, instructs, then moves on. Defaults entered, writ scheduled, because docket must advance, regardless of technical turbulence.
That they were. That is what I presumed that they were. At that juncture, I informed counsel that I had received them. Because I had viewed them as privileged, I had indicated that I would not let the people see them, but that Mr. Burgess could come by our office and look at what had been received. Shortly thereafter, I received Mr. Burgess' motion to withdraw. And basically that was going to be heard today. Almost immediately thereafter receiving that, I then received in, I guess, in our office mail or however it got to me, a letter from the defendant saying all kinds of different things, but indicating that he did wish to represent himself. That letter that he sent was shared with both sides. Today, I provided a copy to the people and also to Mr. Burgess in this case. All right. Is anything from the people?
Your Honor, just that I've spoken to Mr. Burgess about this matter. I don't have an objection to this motion. That's of course discretion. As far as I've been concerned, we've had communications about this case. He has fought diligently for his client.
All right. Mr. Lee, do you not wish Mr. Burgess to represent you in this case?
That is correct, Your Honor.
All right. And the other thing, you wish to represent yourself? Or do you wish the court to sign an order that permits the Office of Manager Assigned Counsel to appoint counsel to represent you?
I would like the latter.
So you want new counsel?
Yes.
So you want at this time and I think it's on page 2 of your communication indicating that you wanted to represent yourself. You want the court to disregard that at this time?
Yes, sir.
You understand that because I'd be appointing new counsel, that's going to require that this matter be adjourned to allow counsel to get up to speed on your case.
Okay. I was unaware of that. Fact. Are we talking a 1 month or a 2-week adjournment? Just curious.
Well, it's wherever the court, I've got a very tight schedule, but we will, what day?
August 19th, Your Honor, would be the date.
It would go out approximately a month.
Okay. I have some upcoming surgeries. And so I will then like to just represent myself because I don't, they're very serious surgeries. And so I don't have the time to wait.
I understand that, but when do you think, if you represent yourself, when do you think your examination would be?
I would object to any further delays, and I would like as soon as possible, convenient with the court and everyone else. I'm prepared.
You're prepared to what?
I'm prepared to take the first available date for the examination as soon as possible.
Well, I don't know what you're asking me to do, Mr. Lee. Have you reviewed all of your discovery and everything?
As far as I know, the discovery was just 2 pages of the interview with the detective and the victim. I have reviewed
I'm
that.
going to probably believe that there's more than just 2
Correct.
pages.
Correct, Your Honor.
He's provided copies too, Judge. He was at my office in May 8th.
So I would need copies of that.
I mean, Mr. Lee, you're not, would I be correct that you are not prepared to go forth today to preliminary examination yourself? I mean, because you keep going back and forth, you want counsel, then you want that.
So I am prepared to go today. Absolutely.
If you represent yourself, you're prepared to go forth today?
Yes.
So what do you want me to do, Mr. Lee?
I would like to proceed today.
Okay, you understand that it cannot finish today.
Sure. I agree. It's fine.
Would the people have a witness they can start with?
Your Honor, we have a witness we can start with. I will say from the record, I do have concerns that if Mr. Lee is going to be representing himself, he's doing so without having all the discovery. And he, of course, will be held to the same standards as any attorney would be held. So a lot of concerns for the people, but we do have a witness available if that's what the court is inclined to do.
Is that really what you want to do, Mr. Lee?
Yes.
I think you're just, I'm gonna be honest with you, I think you're just telling me yes, thinking that you're gonna get a quicker date. And I am not clear that you're ready to go because you only talked about 2 pieces of paper and counsel's telling me there's a whole lot more in this file.
I understand. I'm willing and ready to go
Do you
today.
have a copy of the discovery?
My attorney hasn't provided me with a copy.
That's not true, Judge. I gave it to him on May 8th. He was at my office. He got it.
Or the 2 pages, yes, that's what I have. The
No.
other stuff I don't have.
Your Honor, for the record, not only is there a full police report, but there's also body camera footage. That again, it might be best to review before.
Have you seen the videos, Mr. Lee?
Well, I was there. I'm assuming they're referring to the body cam footage at.
Well, I don't know. You're making assumptions about what exists, and I don't know. Have you seen the body cam footage, Mr. Lee?
No. If you're, no.
Do you still? Ms. Wyman.
Partial payments surface like lifelines. Ledgers appear, receipts waived, numbers disputed. The judge sets hard deadlines. Pay before noon, bring proof, or face possession. Promises mean nothing without dollars and dates.
Would the people be available? It is gonna be a mess on the afternoon of the 8th. It's a Friday.
Should be available. And I August 8th.
Yes, ma'am.
Yes, Your Honor.
All right. Are you gonna be able to, so if I set it on the 8th, sir, and I'm sort of pigeonhole you in on a Friday that I normally wouldn't hold them, but if I do the 8th, are you still wishing to represent yourself or do you wish an attorney?
I'll represent myself.
Your Honor, the one thing I would like to add, because as I stated, we're ready to proceed today. The victim is here on this visitor waiting since this morning. Victim has also been here previously, waiting for an exam. I would just ask that we have no further delays on the 8th.
Yeah, if I'm gonna be done, if you're saying, Mr. Lee, that you're representing yourself and I set this on a special date, I'm not going to at that time, if you wish an attorney, then I'll have to deal with that, but I'm not going to let a delay happen. Okay, we're gonna go on the 8th.
Yes, Your Honor.
Is that what you want to do?
Yes.
All right, I'm just,
Double checking. Days works.
pardon?
Days works for the people.
All right. So that's what I would set. I will advise you at this time, Mr. Lee, you understand that you are charged with the offense of criminal sexual conduct in the 4th degree involving force or coercion. You understand that, sir?
Yes, sir.
And that involves a Stephen Kwanzi. You understand that, sir?
Yes, sir.
You also understand that this is a high court misdemeanor punishable by up to 2 years incarceration, a $500 fine plus court costs, mandatory HIV and STD counseling, and DNA was taken or should have been taken upon your arrest. You understand that, sir?
Yes, sir.
You understand also that this, under the SORA statute or sex offender statute, is a tier 1 offense and would require registration if the victims are 18 years or older. You understand that, sir?
Yes.
All right. And also other requirements, but I'm presuming that the victim is, that's the only one that would be applicable in this test, in this case.
Yes, sir.
You understand all of that? You understand that if you proceed to represent yourself, you do so at great peril, and usually doesn't not necessarily work well for people when they represent themselves, but you are constitutionally entitled to represent yourself. You understand that?
Yes, sir.
You understand also that the court is going to make the assumption or presumption that you understand the Michigan court rules and the procedures used in a courtroom. You understand that, sir?
Yes.
You understand that the court would not be there to assist you in any way regarding this case. You
Yes.
understand that, sir? And you understand that you will not be, the court is not going to treat you worse, and not going to treat you better than any attorney or the prosecutor in the case. You will be held to that same standard in conducting this.
Yes.
All right. Understanding all of that, you still wish to proceed representing yourself, sir?
Yes, Your Honor.
All right.
Your Honor, just for clarification, does the defendant want to stand by counsel?
He has not asked for it. I'm not offering it.
I'll take one if it's available. Thank you.
Well, there's going to be a funding issue regarding that. I'll make that determination as to whether or not there be standby counsel, because that can be done elsewise other than this. I will adjourn the preliminary examination in this matter to August 8th, 2025 at 12 noon. That's before me.
bond violation will follow.
Yes, is that and the bond violation. Yes.
The defense is requesting, you to, examine the information between myself and my attorney, because I am alleging that I did not violate the, bond, the condition of the no contact order of my bond, and, witness tampering, that the prosecution says that I'm guilty of, and the text messages prove,
You're asking me to look at information that would be relevant to the bond hearing?
the text messaging between myself and my attorney, and then the Google AI searches that prove my motive and intent for making the phone call between myself.
Sir, this is, and you're asking me to look at it in reference to the bond violation.
Yes, because I think it should be reinstated.
I will address that on the 8th.
Okay, thank you.
Okay, I'm not making a guarantee I'll look at it or not. I don't know whether or not it's relevant, but I will deal with that on the 8th. At this point, his bond will continue. Thank you. What I'm gonna do, and I realize I have 3 short matters, I'm gonna take a break, allow the press to break down, get themselves out, and then I'll come back out. Court is standing recess. All right.